Hey, Chad Brown, welcome to Disability Expert Podcast, where we talk about all things Social Security disability. I am back with my trusted associate, Aaron Dalton.
Glad to be back.
Yeah, man, glad you're here because we're talking about something you candidly do more of than I do at this point, right? So, preparing for your Social Security disability hearing. So, one of the questions we get asked a lot by our clients and just every day in the practice is, well, what's the hearing going to be like? Who's going to be there? What should I wear? Uh, where is it going to be? How do I get the video up on my phone if it's a video hearing, right? So we thought we'd stop today and take a little time and walk through what actually you need to do to prepare for a Social Security disability hearing. We're not going to talk about all the things you should do to get your case prepared for a hearing. That's not the topic. We're not going to talk, at least I don't plan on talking about what happens after your hearing if you win or lose. This is, you have your hearing notice, you're in that tight window the month before your hearing, and all of a sudden it hits you, man, it's here. Like, this is it.
This is the big day.
This is the day. This is, and they're going to come in. Client's going to come in, do a pre-hearing. I know you did. I know I heard it. So I'd shut the door. You did a
Had one this morning.
Yeah, you did a pre-hearing this morning. So let's just start with, tell people just broadly, what is a disability hearing? Because it's not like other court proceedings. So what actually is a disability hearing in terms of generally how it works?
To start off with, it's much less formal than a standard hearing, maybe in a different practice area. I think a lot of clients either have Judge Judy or a "you can't handle the truth" moment. They're much more tame than that. They're about 30 to 60 minutes. You're in more of a conference room really than a courtroom, with the judge, with your attorney, with the court reporter, and with the vocational expert. And it's really the first chance in a disability case that you have to talk with a decision maker about your case. Because up till now, so we've talked about in other episodes, it's mainly just based on filings. But here you actually get to talk about what's going on with the person who's deciding your case.
Right. And the Social Security disability process is supposed to be non-adversarial. So, and it's in the, at the hearing level, you're still in an administrative court. It's not that there's not any formality.
Right. It's still under oath.
But at the same time, it's more of a opportunity to sit down and sort of have a conversation. I know pre-COVID, things were very different. I know we drove, I don't know, at some point, I think my truck has 330,000 miles on it. I think I got 230,000 of those before COVID. Because literally you would drive, you'd go, you'd sit at the hearing, you would go in and do an in-person hearing. Even before COVID, they were transitioning into some phone hearings, and you had some experimentation with that by the Social Security Administration. Post-COVID, talk a little bit about what are the different modalities which you can have a hearing and how most of them actually happen today.
Sure. So when we are filing the request for hearing, one of the things we're talking to clients about is how they want their hearing to occur. So there's three types of hearings that we can do. We can do a hearing by phone where we're all just on one big conference call. We can do a hearing by Microsoft Teams where we can all see each other, but maybe in various locations. And then there's still the in-person option, which is going to be at the relevant hearings office. So for us, a lot of times it's either Greensboro or Charlotte.
Right. Yeah. And the video works in various ways as well. And sometimes our client will actually be at home on their computer or even on the phone, even though that's candidly not preferred.
Yeah, I usually recommend do not do phone unless that's your only option.
Right. But a lot of times our clients actually come in and actually use our conference room, and we'll do video hearings here. So we're still with the client, but we're appearing by video. And by the time we get to the thing we're talking about today, though, that decision by and large has been made. There are some exceptions. There are ways to change that. Sometimes people choose and don't really, or they're not represented at that point,
Right.
and they don't really understand the different modalities and why you might want to have a in-person hearing versus a phone hearing versus a video hearing. That's probably another episode.
Probably another episode. One thing to note on that point, though, is if you do come to the point where you're needing to change your modality, sometimes that can result in a delay. So if you were originally scheduled for an in-person, for example, and you need to switch to video, you may not be able to keep the same date and time with the judge.
Sure. We're having an informal hearing. We're with the judge. We've talked a little bit about the people that are in the room. Just sort of walk through sort of what's the introduction to the hearing like. So we've got into the hearing room, or we open the video, and just sort of walk through sort of what's that sort of initial part like, because I think a lot of times there's a lot of administrative stuff that happens and the client doesn't really know what to do, and the answer is they shouldn't do anything, is just sit there and be quiet. But sort of walk through a little bit about that intro, and then we'll dive into what actually goes on in these hearings.
So there's several housekeeping things that happen at the start of the hearing. The judges sometimes do it in a little bit of different order, but basically they're going to be asking the client to identify themselves, birthday, social, mailing address. I'll introduce myself for the record, note that I'm the attorney on the case. And then the judge and I will go over some housekeeping things. We'll talk about the medical records. We'll talk about, are we waiting on any medical records? Do we have any objections to what's on the file? And essentially, the judge will also confirm with me that my client and I have talked before the hearing, and I've explained big picture what's going on, so the judge doesn't have to that day.
Right. Because if you appear in a hearing, and I know you see this because we see transcripts of people who are unrepresented, the introductory components of a hearing with an unrepresented person are far more.
Oh, they're much longer.
Yeah, they're much more detailed. The other thing that happens too is typically there is a confirmation of the modality. We're doing a video hearing today. You're in agreement with that. You're okay with that. You understand the implications of that. So they'll go through and sort of, jump through the administrative hoops they have to clear up evidence of issues and make sure we're okay with the record and identify everybody. And then the hearing starts. Now, it'd be impossible to classify every judge, but different judges do hearings differently. So can you talk maybe about some of the major ways that judges conduct hearings? Some of them say, it's up to you, counsel, start, right? And others, by the time you get done, there's no questions to ask. So can you just sort of walk through maybe some of the different various ways that the judges conduct hearings?
So a lot of the judges will start the hearing by asking me for an opening statement. So I'll sort of summarize our theory of the case, maybe hit the highlights of what's in the evidence, kind of roadmap where we expect the testimony to go. And then, like you said, some of the judges immediately turn things over to me and say, well, counsel, make your case. Other judges will do sort of a high-level questioning where they will start with the work history, going back 5 years, talking to my client about what their past work was. And then the judge might do kind of a big picture overview of what's been going on with the top 2 or 3 or 4 medical conditions. And then the judge may ask about activities of daily living, things you can and can't do, relatives helping you out with chores, things of that nature. And then the judge kind of leaves it to me to ask a couple of follow-ups. So depending on how thorough the judge is, I may have 5 minutes of follow-ups. I may have no follow-ups.
And I think those are sort of, there's sort of three, I don't know, there's more than that, but you sort of have judges who really don't do any questioning except, well, sometimes they don't do any questioning and they just interrupt you the whole time.
Yes, that happens too.
So you're kind of like, well, why don't you just ask the questions, judge? Like, it'd be a lot easier if you quit interrupting me or you do the questioning, but me doing the questioning and you interrupting me, that can be frustrating. But hey, it's the judge's court. They get to do what they want to do, right? So, but usually you have the judge will sort of turn it over to you, and then, they may have some follow-ups along the way, or they run the whole hearing themselves, where they really sort of take command of the hearing, and they're, really controlling almost every question that's asked. But a lot of them are in sort of this hybrid model where they want to get the work history, they want to clarify impairments, they want to get some basic information, and then you sort of, what I always feel like doing is you're just sort of filling in the gaps.
Right.
So it's like, well, the judge asked this, but it's probably based on the question he asked, didn't get the information completely accurate. And so, we're sort of filling in the gaps like that. So you're going to have one of these judges, and I mean, just generally you're going to know. I think one of the benefits of working with counsel. And sometimes we don't know, right? Because we'll get judges all over the country when they move cases around. But if you are familiar with the judge, that helps tremendously. And I know a lot of times in the pre-hearing, what you're trying to do is help the client understand, because if the judge is not going to ask any questions, those are, I consider, to be relatively safe hearings, because it's highly unlikely I'm going to ask a bad question, right? But when the judges completely control the hearing, it's really valuable to know sort of their method of questioning, points they really like to focus on. I remember there was a judge once who's now retired, but name I won't use, who had a very, very specific, highly aggressive form of questioning. And some of us sort of put together a list of questions, and we really prepared our clients, because he was very predictable. And so we would come in and he would almost look surprised sometimes, because it was like, how do you know the answer? How did you know I was going to ask that? And they were like, well, because we prepared.
Done a couple hearings with you
We've done a
before.
couple hearings, right? So I think it's good for the client to know that, because it does sort of help them understand, hey, this could be tense, or it's going to be pretty relaxed. This is not something you should stress out a lot about. So in the course of the questioning, let's just talk a little bit about, I don't know, let's just talk a little bit of detail. So with work history, I think it's important that they just have command of it before the hearing.
Right.
Especially if maybe they were in like what's equivalent of a composite job, where maybe they were working as a supervisor, but they also were working as an employee in the company. Being able to draw out those distinctions, because they can impact the VE test, the VE questioning and testimony down the road. With your medical impairments, what are the things that you're wanting the client to make sure comes out in a hearing? Like in terms of that preparing for the hearing and what to expect, what are the main components that you want to come out of? It's probably an unfairly broad question, but generically about the medical conditions, what are you trying to get out?
So one of the top things that I'm trying to get out in testimony is, why did what was going on with your medical impairment impact why you left your job when you left your job? So sometimes we have clients who want to testify, well, I've had migraines since I turned 18. Okay, but you worked for 30 years after that. Why did you leave work when you left work? And so really tying that disability start date to the medical conditions is very important. I'm also trying to help clients, especially in the pre-hearing, understand that, these are only 30 to 60-minute hearings, so we may not have time for your entire life story. So we really need to tailor it to the top, 2, 3, 4 medical conditions that have impacted you for greater than 12 months.
Right. And I think that gets to another point that clients need to understand. When we're questioning, but especially when the judge is doing the questioning, and it's this, I've said this once, I've said it 1,000 times, just answer the question that they ask.
Yes, listen closely.
Yeah, listen closely and answer the question they ask, because the reality is that some judges have no tolerance for that, and they will cut you off and they become rude.
Yep.
But a lot of judges, like if you want to word vomit all over your hearing, they're not going to stop you.
Right.
And so you end up with them asking, well, when did you have your knee surgery? And you're talking about your gallbladder and your knee problem, and you're talking about your shoulder problem. And like, all he really asked was when the surgery was, right? I think one of the things that's helpful for clients to keep in mind is, I used to tell clients, when you're preparing for the hearing and the judge asks you a question, answer the question that they asked. But a lot of times what happens is the question that the judge asked doesn't allow you to give a full and fair answer.
Right.
And so, I think it's important that they realize we get to ask questions.
Yes, that's what I'm there for.
Right, yeah.
Don't do my job for me.
Yeah, well, because if the judge doesn't ask something or ask it in such a way that leads to a misleading sort of answer from you, we're going to come back and rehabilitate that.
Absolutely.
Yeah, we're going to follow up with we think's the proper question or the proper sequence and context of the question, right? So that they can do that. But it's one of these, and once again, this sort of falls on both sides of the spectrum. You have some clients who are very anxious and very nervous in the hearing, and they respond to that by talking. And so they just talk and talk and talk, and you're like, "God, just be quiet." Like, you're not helping yourself, and that wasn't what they asked, right? You're not mad at your client, you understand where they're coming from. Yeah, but the other side, or the person becomes nervous and they clam up,
Right.
and the judge is, "Well, tell me how this impacts you," and they're like, "Well, it hurts."
Right.
You're like, "Well, that doesn't help either," right? Because now you've gone the other way. So it's giving a thoughtful answer to the question that's asked, but recognizing that one question is not the only opportunity there's going to be to explore this issue that's central to your case.
The other thing I try to help clients understand is the answer does not have to be perfect, and it doesn't have to be, you know, super, super precise. You can give ranges. You can give good days, you can give bad days. You can say 15 to 20 minutes. Anything like that is acceptable in answering the question.
Yeah, and this is sort of like a recurring theme that comes up in a lot of different contexts in the disability process is you need to be accurate. You don't need to exaggerate, and you don't need to minimize. You need to be accurate, and you need to give clear examples that demonstrate your point. So once again, if you have difficulty lifting, it's much easier to say, I have a 20-pound grandchild and I can't lift them because it's not safe. That's a clear example. It gives a limitation. It puts it in vocational terms than to just say, well, I can't lift anymore, right?
Right.
But at the same time, if you say I can't lift anything, and
We-
it's like, really? How do you draw off when you get out of the shower?
Right.
Do you have someone that lifts the towel for you? And you get into these sort of absurd scenarios, which most judges thankfully don't sort of bring to the conclusion that could come to them, right? But it still hurts your credibility, and I think it doesn't help your testimony. The other thing I think is important with respect to the medical evidence testimony, this golden chain of evidentiary progression that we talk about, where you're trying to go from diagnosis to symptom to functional limitation. And a lot of times in the hearings, what the client wants to do is sort of talk a lot about the diagnoses, and that's not really necessary.
Right.
That's what the medical records are for. It is important to talk about symptoms, but a lot of that's in the medical record as well. It's really your time to link that final piece of the chain and really highlight your functional limitations. And then we, in our brief and in our closing, we're going to draw those connections and say, well, it's reasonable that they have this diagnosis of degenerative joint disease in their hip, and that causes pain, and they're telling you that they can't sit. Well, now that all makes sense. But your testimony is the opportunity for you to make sure that the functional limitations and any symptoms that might not be obvious are testified to, so that we can build that causal link between impairment to limitation, so that when they build the RFC, they build it correctly based on the evidence and your testimony.
Absolutely. One of the things that I talk to clients about is, the judges are specialists themselves in disability cases. They might hear 3, 4, 500 disability cases a year. They don't need for you to explain to them what your diagnostic code is. They got that part. They need to know what it looks like in your case, in your life.
You always love when the client comes in like, "You've never represented anybody that has what I have," and they realize really quickly, well, actually, we have multiple people. It does happen, and it does happen to the judges, but by and large, they're intimately familiar with all of your medical conditions.
Right.
Right. So let's do two things. I don't want to spend a ton of time with the VE. The VE is going to respond to a hypothetical from the judge. They're a neutral witness. They're not against you, even though it may feel that way. What are a couple of things not to do so we get to the end of the hearing? A lot of times the vocational expert is going to testify. It's part of the step 5 process. We've done some episodes where we talked about RFC and step 5 and the grids. We finally did do a grids episode, even though it's out by now. The vocational expert is part of that step 5 process. What are some things you shouldn't do, though? Because I think this can really irritate judges. What are some things you shouldn't do during the VE testimony?
Don't interrupt the VE when they're talking. If you're represented, if I'm in the room with you, let me handle talking to the VE. I can usually get a pretty good sense of what's going on, what they're talking about, so the judges can get a little bit I guess, defensive of the vocational experts. If clients start, you definitely don't want to be yelling at the VE during your hearing.
Right. The other thing I think that sometimes they don't directly confront the VE, but they'll say, "I can't do that,"
Right.
or they say, "I didn't do that about your job," or they'll say, "I don't even know what that job is."
Yes.
And I think the easiest thing for you to do if you're in a hearing and the VE says something you don't understand, it's perfectly acceptable to have a pad,
Oh, sure.
write a note, hand it to me, hand it to, your attorney and say, "Hey, I don't think that's right," where we can very quickly say, "Don't worry about it. It doesn't apply to you," or, "Okay, thanks.
Good point.
Good point. Let me follow up on that." Um, let's talk about just hearing conduct generally though. So we've talked about the hearing and the process and sort of the high points in the VE, but I do think we can leave people with some general takeaways about things that help have a good hearing.
Yes.
Okay, let's talk about promptness.
Yes. Get there.
So why is that so important?
The judges are on a very tight schedule. They might have, 4 or 5 other hearings the same day as your hearing. So I try to tell clients, you want to be there 30 minutes early. If the judge is ready to go early, we need to be ready to go early to help keep their calendar scheduled for them.
And I think with the technology of hearings, um, with phone, like you need to make sure if it's a telephone here and you're using a cell phone, you need to make sure your battery's charged.
Yes. And don't be driving, please.
Yeah, don't drive. That's not helpful. I've had that happen. And sometimes and they're like, "Well, my battery doesn't stay charged." I'm like, "Plug it in."
Yes.
Right. And same with the video. Like it's perfectly fine. We can run a Teams test before your hearing, thinking about backgrounds. Like you want a neutral background.
Please don't have anything distracting behind your head during the hearing.
Yeah. Don't do it in the living room with the TV on in the background and your three cats on the couch and
Dogs barking.
and your grandbaby that you're not keeping all the time, right? Yeah. So quiet room, test the technology, make sure it works, give the judge the best opportunity to hear you because I mean, if they can't, they don't necessarily have to do another hearing just because you couldn't clearly present your case because you didn't take the time to prepare for those. And honestly, we have cases too. I know where there's difficulty with the technology. I want to say, was it last year? I think we met a client at the library. We got a conference room. And we did a video here. I mean, so there's always a solution, but the solution needs to be figured out beforehand, not after time. What about dress?
That's a great question. I think we've talked about this on an earlier episode.
Yeah.
Please don't wear any political slogans. Right. Don't wear anything that's the judge is going to remember. You want to be as neutral, blah colored as you can, so the judge will forget what you're wearing as soon as you leave.
Don't wear provocative clothing. It's completely inappropriate.
Judge should not see your shoulders.
Yeah, I mean, it's just wear I mean, but also, and similar to like I think we did an episode on maybe the CE, on maybe consultative exams, where it's like where if you wear slides because you have significant swelling in your feet, wear slides.
Oh yeah, that's fine.
Yeah, but at the same time, you're still making a first impression,
Right.
and you really need to make a good one.
Yes, clothes should be clean. Other thing I talk to clients about, if you have a condition that results in pain from you sitting for too long, it is okay to sit and stand during the hearing. You can let the judge know what's going on. Don't think that out of respect or something, you have to sit there and just be, white knuckling in pain.
Right. Also in just being, just sort of being aware that it's okay to pause and answer a question.
Yes.
You don't know what the questions are going to be exactly. It's okay to take a time and think. It's okay to ask to repeat the question if you don't understand it.
Absolutely.
Golly, I've been how many times in hearing like the client answer the question and I'm like, why did you say that? And they're like, well, he asked this. And no, that's not what he asked.
What I heard.
So being respectful to the judge.
Absolutely.
Some of these hearings are combative. I mean, every judge is not kind. And there's a lot of similarities to how you should conduct yourself in the hearing and how you conduct yourself in the consultative exams. It doesn't cost anything to be kind, right? It doesn't, Be polite, be respectful. They have a lot of power over what happens in your case with the judge. So, um, I think the other thing, the final takeaway would be, uh, you're going to take an oath at the beginning of the hearing to tell the truth, and you need to tell the truth.
Yes.
If you don't remember, it's okay to say, I don't remember. If you don't know, it's okay to say, I don't know. What's not okay is telling something that's to be untrue.
Absolutely.
And I think if you follow those, I think you can have a good shot, having a good hearing. There's more to it. We're out of time. All right, that's it. How to prepare for your hearing. Hope that was helpful. There's some other deep issues here. We'll have to come back and hit some of these on a deeper level. But for now, that's it. Thanks for watching. Subscribe. Till next time, take care.